5 seconds to go. Start. In the case of B. Jayaraj, the complainant did not support the prosecution case. Stop. In P. Satyanarayana Murthy, the complainant had died prior to letting in his evidence in the case. Stop. In M. Narsinga Rao, the question was whether a legal presumption could be based on a factual presumption. Stop. In Hajari Lal, this court through O. Chinnappa Reddy, judge observed that it is not necessary that the passing of money should be proved by direct evidence, it could also be proved by circumstantial evidence. Stop. Furthermore, in Madhukar Joshi versus State of Maharashtra 2008 SCC 571, it was observed that in order to draw a presumption under section 20 of the Act, the premise is that there was payment or acceptance of gratification. Stop. Once the said premise is established, the inference to be drawn is that the said gratification was accepted as a motive or reward for doing or forbearing to do any official act. Stop. Para. P. Satyanarayana Murthy has been referred to in State versus Dr. Anup Kumar Srivastava 2017 15 SCC 560 by observing that what constitutes illegal gratification is a question of law, whether on the evidence let in, crime has been committed or not is a question of fact. Stop. If, therefore, the evidence regarding the demand and acceptance of a bribe leaves room for doubt and does not displace wholly, the presumption of innocence, the charge cannot be said to have been established. Stop. The court also made observations regarding framing of charge in a criminal trial where the court is expected to apply its mind to the entire record and documents placed therewith before the court. Stop. It was also held that proof of demand is an indispensable mandate for the offence under sections 7 and 13 of the Act. Stop. On the facts of the said case, it was held that the same was absent and the accused was liable to be acquitted. Stop. Para. In all the cases leading to the reference, it is either the death or the refusal to support the prosecution case that has led to the legal presumption under section 20 of the Act not being raised and not bringing home the guilt of the accused. Stop. Para. Learned ASG and counsel also drew our attention to the following precedents. Para. In the case of State of Andhra Pradesh versus V. Rao 2004-9 SCC 319, this court, in the absence of the complainant due to his death, proceeded to convict the accused based on the evidence available on record and further held that for the purpose of reaching a conclusion, the court can rely on factual presumption under section 114 of the Evidence Act. Stop. A fact may also be proved by direct testimony or by circumstantial evidence. Stop. Para. In Kishan Chand Mangal, this court upheld the conviction based on the evidence of the shadow witnesses. Stop. Similarly, when the complainant died during the pendency of the trial, this court convicted the accused by relying upon the evidence of the other witnesses, as the factum of demand, acceptance and recovery of the tainted money was proved by the prosecution. Stop. Para. In contradiction to the aforesaid cases, our attention was drawn, wherein on the death of the complainant, acquittal was ordered as the accused was relieved from his duty and was not competent to transact any official business apart from the fact that there was contradiction in the version of witnesses. Stop. Para. The acquittal was based on the ground that there was no other evidence to fall back upon in the absence of the complainant letting in evidence. Stop.